Welcome to the TPRM Exchange podcast, brought to you by the Third-Party Risk Association, a not-for-profit, practitioner-led, and framework-agnostic professional organization for third-party risk management professionals.
Hello, and welcome to the TPRM Exchange, produced by the Third-Party Risk Association. I'm your host, Hilary Jewhurst, and this podcast is practitioner-focused. We look at how third-party risk management really works in programs and decision-making, not just your policy documents. So today we're talking about something that really sits at the intersection of law, compliance, and vendor oversight. What we're trying to understand is sanctions in the context of third-party risk management. We'll look at what they actually are, why they matter, and what failures can cost. So to help unpack this, we're joined by a fantastic guest today, someone who this is their day-to-day work. Let me introduce Michael Volkov from Volkov Law Group. Michael, thanks for being here today.
Well, thank you so much, Hilary. It's great to be here, and it's great to participate with the Third-Party Risk Association. The work you do is so important, and I think it's just a terrific resource for everybody out there in the business community looking for ways to mitigate third-party risk.
Oh, thank you. We appreciate that. So to get started, let's talk about your background a little bit and how you came to become focused on sanctions and third-party risk.
Well, as you can tell from my gray hair, for many years I was a federal prosecutor for 25 years in Washington, D.C., and worked on criminal cases, obviously. And then I went out into private practice in early 2000 and got immediately involved in compliance. And in compliance with the FCPA, sanctions, everything, what's right at the core of that is third-party risk. And because of that, I've spent a lot of time working with clients, companies of different sorts, different industries, different permutations on managing third-party risk. And that has been a big part of my work in terms of in the ethics and compliance field.
Great. So you are exactly the right person to have with us today. So just to get started, a little icebreaker question for you. So when you're working with clients on, sanctions in that third-party risk context, what is a simple kind of everyday assumption they make that might worry you the most?
The most significant assumption I see is that some people believe that when they deal with a third party outside of, let's say, the United States, they send a product through Canada to a third party, let's say, for example, and they'll think, okay, the sanctions do not apply. The US sanctions do not apply because it's being handled by an entity which may be under our control, obviously, in Canada. And that is just not true. The risk continues from wherever you're located. If you're a US person or a US company, it continues through your third parties, no matter where they are located.
Okay, that's a great framing for today's topic. So to get started, let's get into what sanctions are. We have a lot of new practitioners that listen. So why don't you give us a sort of 101 on sanctions?
Well, that's a great way to start, I think, because the sanctions authority comes from a statute which gives the power to the government, the executive branch, to impose sanctions on various entities in the interest of national security and foreign policy, the US's foreign policy. So, for example, then that is administered by OFAC, which is in the Department of Treasury, and it's called the Office of Foreign Asset Control. And OFAC then maintains what are called sanctions, and they're usually coordinated with the US State Department. And there are various different types of sanctions. One is what's called purpose-driven sanctions. And that is, for example, we don't want people to engage in nuclear proliferation or terrorism. And we may, as under that authority, designate various entities or individuals, and they will be sanctioned, which means that no U.S. person is allowed to conduct business with them. They cannot conduct a financial transaction with them. And that is a very broad definition of a transaction and a financial transaction or cause of violation. Besides purpose-driven, so that's one category. The second is what I would call specially designated or selective sanctions. And those are, and we've all heard of what is called the specially designated nationals. And that in the industry is referred to SDNs. And you don't want to be an SDN. I will tell you that, because if you're an entity, a vessel, or an individual, and you are designated as an SDN, again, you're not allowed to conduct business with that person. No financial transactions are permitted. And you can be located anywhere in the world, in the United States, outside the United States. Then we also have the last category I would sort of pull out, refer to, is the country or a country-wide. Let's say we've heard these called the Venezuelan sanctions, the Iranian sanctions, and these are, or the Russian sanctions, which are very significant. And these are purpose-driven, directed towards a country, but could be a comprehensive embargo, like Cuba, for example, or North Korea, but it also can be a set of specific sanctions against individuals, industries, like the oil industry, or against various parts of a country, all the way up to an embargo. And those are country-related sanctions. Now, this list is maintained, and we ordinarily, there are techniques or technologies that are allowed to or permitted to conduct searches of these lists to see whether or not somebody is on the list. And then when you're on the list or you're close to a list entry, then you need to examine who it is and dig into who owns them and exactly whether or not you can deal with these individuals. So that's basically, remember the three categories: purpose-driven, selective SDNs, or country programs. And so the most, I would say, significant that we run into across everywhere, and everybody knows this language, it's called the SDNs. That's the most significant term you're going to hear. Is that person an SDN? Okay, and it means specially designated national again.
Okay. So we definitely have a combination of sort of economic sanctions. We have sanctions against individuals. We have export controls. So where, from your experience, are you showing or experiencing sanctions kind of showing up in the third party life cycle? Is that something that we're looking at in onboarding? Are we seeing it more in the monitoring where we see changes of ownerships, payments? Where do you think are some of the most common places for sanctions to show up?
By far and away, the most significant occurrence is on when you're onboarding or about to make a shipment or a sale, and you screen the individual or the business where you're sending, let's say, a product. And at that point, when you onboard a buyer or you're onboarding, let's say, a vendor from whom you're buying, okay, because we have both in the supply side and the distribution side, we have to worry about this. When you're onboarding, that's usually when there's a sanctions due diligence that is performed to make sure that you can put them, let's say, within your system, in your vendor master database, or in your distribution system, in however that's organized, if you have channel partners or whatever you deal with. So you're very, very clear about, and it's good that you picked out onboarding first, because that's where I would say 80% to 90% of these situations come up. Now,
Mm,
in a small percentage, we also see situations where, let's say, after Russia invaded Ukraine, a lot of people were put on these lists and prohibitions very fast. So then there was a monitoring sort of occurrence that would come up. You'd get a notice that, hey, this vendor or this customer that you had onboarded is now designated by the OFAC. Okay. And then that requires you to take certain steps. But most of the time it's onboarding. And that's where we need to all think about how do we build in controls that are going to allow the business to operate and move forward and catch it at the right time and hopefully resolve red flags and then permit the business to go forward. Now,
yeah.
let me just say one last thing,
Mhm.
Hilary, and I know I don't want to go on for too long, but what happens when you don't do that? If your controls are not in place, the banks are viewed as probably the first line of defense by the government.
Mhm.
And the reason is because they have very robust sanctions compliance programs. And if your bank sees that you're involved in a transaction with a prohibited entity, they will block the transaction and they will
Mm,
freeze the money. So you don't want to be in that situation. And I've gotten calls in that situation, and it's very difficult to deal with. As opposed to if you look at this in advance on the onboarding process, no bank is going to stop it if it's legal and you clear everything. So that's why it's onboarding, but remember the bank is behind it. And the last thing you want is a call from your bank saying, sorry, we had to block this because it's a prohibited person under the Iranian sanctions program.
Okay, that's really helpful. So just to recap, when I'm onboarding a vendor and I'm I haven't even gone through my very deep due diligence, one of the first steps that organizations can and should take is just making sure that that organization is not sanctioned, right? That's the
Right,
first
right.
step. What about we call them principals a lot, but the people running the organization? In your mind, is there a reason to do checks on both the organization and the principals? Or do you feel like that's typically offered as sort of one sanctions check?
Um, yeah, you've hit you've hit a very important issue, Hillary, which is that there are under the various sanctions programs, some of them extend and are very aggressive as to beneficial owners.
Hmm.
So not only principals, not only your officers and directors, but who actually owns that company. And I will tell you, the Russians, for example, are very adept, or they think they're adept, at using shell companies and using fake or close family members as a way to avoid the sanctions scrutiny. And the reason is that a prohibited person who has 50% or more of a company, that person is prohibited, but so is the company if they own or control 50% or more.
Mm,
So when you say that, we normally will start our sanctions review by getting the name of the company and running that. And there, if that company is associated with an individual, you usually will get a red flag, and you will then have to do a little bit more inquiry as to tell me who all your officers and directors are, tell me who your beneficial owners are. So that's why we start with the company and then we go from there. Or if you're dealing with an individual, like an agent or a distributor, you would start with that individual sometimes. But most of the time, you're starting with an entity.
okay. So obviously there's a lot of reach from sanctions. What about fourth parties, right? Like your vendors' vendors. Um, Can you give us some practical insight on the accountability level we have for those with sanctions, what we should watch out for, what to keep in mind when it comes to those organizations that you're not directly contracted with, but are in the supply chain or the payment chain?
Well, that is nowadays we call it and you've heard this term obviously, the nth party, which
Yes.
means after the third party, we don't want to go, we go to fourth, fifth, sixth. So let me try to boil it down simply. On the supply chain side, um, there's a lot of regulation on the supply chain side that's becoming more prevalent. One, human trafficking, modern slavery. Companies are being sort of pressured to make sure they can identify and manage their entire supply chain. And it's even more important in the context of sanctions. Let's say, for example, I make a widget and then one of my suppliers on, let's say, the fifth level down is bringing me materials from North Korea and unbeknownst to me, then sells it to another vendor who in turn sells to another vendor who in turn sells to me. I am liable for that vendor, and I am liable for that North Korean transaction unless I conduct regular supply chain audits. I obtain all of the sort of necessary contractual provisions that limit my liability in my supply chain. There's a very famous case in 2019 called Elf Cosmetics, where
Mhm.
unbeknownst to this company, in their supply chain, a Chinese supplier was obtaining eyelashes from North Korea. And then they sold it, and then it got sold and sold up to the California company. That California company, without any knowledge of the North Korean supplied eyelashes, was required to pay a $1 million fine, close to 1 million. And that was a reputational hit that they took because OFAC brought an enforcement action against them. So that's on the supply side. Flip it now, and let's talk about the distribution side. You also, for example, I sell to somebody in Dubai who's a purchaser. I call them a customer, but I know that they are likely to send my refrigerators to Iran. And
Mm.
Dubai is a very significant transshipment point. I am liable if I have reason to know that that refrigerator could go or would go to Iran. And there again, I have to do due diligence, I have to get contractual provisions, and I have to make sure that the end use of that refrigerator is not going to end up in Iran.
Right. So clearly, I think you've done a great job of explaining what sanctions are and how they sort of work. What happens when you get caught doing business with a sanctioned entity? What are some of the penalties and fallout from that?
Well, the game has changed significantly, and I'm not. People who know me in the compliance field and know what I represent and talk about, I'm not a fear monger. I'm not a person who says we're all going to go to jail because we're not all going to go to jail. If you operate in good faith, if you operate and do the best that you can, nothing will ever really seriously happen to you. You're not committing a crime. You cannot accidentally commit a crime. But what has happened in this under the Trump administration is that trade enforcement has become even more important for obvious reasons. They have tariffs, but they also are very aggressive about enforcement of sanctions, and they are now have dedicated criminal prosecutors to criminal sanctions
Mm.
prosecutions. And so I want to say it used to be years ago, 10 years ago, these would all be handled by OFAC on a civil resolution of a penalty of some sort. Now we're in a situation where we are now having criminal cases brought as well as OFAC bringing civil cases. What's likely to happen is that people, if you become aware of that, your immediate obvious thing is to stop the transaction as quickly as you can if you find it. Then OFAC runs a very robust, what's called voluntary disclosure program. And I've had situations where somebody accidentally ended up sending materials to Iran and it was food stuff. And it turned out that it was all by accident or lack of knowledge. Under
Mm,
the voluntary disclosure program, you can come to OFAC and say, we did this, here's why it happened, and here's what we've done to make sure it won't happen again.
yeah,
What you don't want to do is ignore an OFAC subpoena,
yeah,
ignore an
no,
OFAC inquiry. Well, there was a couple companies that did, and they paid for that. And you don't want to ignore a Justice Department grand jury subpoena relating to sanctions. So oftentimes people discover these on their own. We investigate the problem, we fix the problem, and we stay out of trouble, to be honest with you. Um, and they're only where the situations get more serious is when you have, let's say, a CEO who says, I want to keep dealing with Iran and forces everybody to continue dealing with Iran. That's handled in a much different way.
yeah. Oh, well, so there's a lot to consider that, it's a big deal, as they say. So let's talk about our third party manager, mm, out there in the world. They have a program. Maybe it's a smaller program. What do you see as kind of the starting point? What are like the minimums that we should be looking at as, life cycle processes and controls to address sanctions?
Well, that's a great point, a great question, because when I start with people, the first thing is to get an automated screening program that screens entities and individuals for sanctions, and for any and adverse media and things like that. Start with that. The good thing is that OFAC has put out guidance in 2019. They put out guidance on how to build a compliance program. And you can use that as a good go by. It helps you. And obviously, we help companies do that. But the main thing is to start with an automated screening program and at least become a part of the approval process for any transaction. So that
Mm,
once that person, so for example, when you onboard a new vendor, that there's a sanctions screening, a sanctions checkoff, and before it goes into the vendor data master, master database and their payment information is put in, you know that they've been screened for sanctions compliance.
mm,
And then and usually it's not a big burdensome process. We'll start from there in terms of all of our third parties. The one piece of advice I would give everybody, do not think that you have to screen everybody that you've dealt with in the past. Start on day one, be reasonable, and build from there. When you have time or something comes up, you may go back and look. But for example, it's more important to start from day one. Set a day one and start to build your program. You're not going to boil the ocean over this. We don't have time for that, nor the resources.
yeah. You bring up a really good point. I mean, personally, I've been in a program that was implementing formal sanction screening, so onboarding a tool and developing the process. But the fact of the matter is that we had hundreds of vendors that had not been
Right.
screened, and so obviously the line in the sand, everything from this day forward automatically goes through this process, regardless of spend. Because that's another thing people think, well, if it's not a lot of money, it doesn't matter. But because you can do sanctions checking through these tools fairly easily, it should just become sort of a de facto, like making sure they're a legitimate business entity, things like that.
Correct.
But we also, as a secondary process, in that roadmap was to go back and look at where we had the most exposure. So, we're working in foreign countries where we have a lot of spend, where we have very regulated products and services that are being supported by vendors in those spaces to kind of play catch up. And then from there, we also implemented so we had our list, and any vendor that was on the list got passed through the list again on a quarterly basis, right, to help us with the monitoring. So, because to your point earlier, it is not inconceivable that someone who's okay today may not be okay tomorrow.
Well, that you hit the nail right on the head, because sanctions change weekly. People get put on the list weekly, and you have to stay up on it. And what usually happens, most of the automated programs that I work with now that are out there in the marketplace, once you screen somebody, they stay in the system. And then if they are designated down the road, you will get a notice that
Yes.
that will happen. Now, I like your approach, though, the way, Hilary, you talked about going back, but and I'm all for that, and I agree with you. You look at spend and you look at the risk of the country by location. For
Hmm.
example, Northern China vendors are higher risk than Southern China vendors because of their proximity to North Korea. And so I think you hold those vendors in a higher risk category than you might hold, people who are in the south of China. Vendors who are in Eastern Europe and their proximity to Russia, they may be more interesting to you than vendors who are on, Gibraltar and the western part of Europe. But
Yeah.
there are known transshipment points. This is the one great thing, great, as I say, in comparison to FCPA and anti-corruption, is there are various geographic factors that help to limit the risk when you're talking about sanctions. And that your idea of looking at spend and looking at location is a really important practical insight. And I would urge everybody to think about what Hilary said,
Well,
what you said about that, because it helps to make it a more manageable risk the way you described it. So that's because you were actually doing it,
yeah.
and in the job that you had at that time. So I think so let's but but my focus is, let's look forward, and we'll do look backs when we have the chance. But the most
Exactly.
important thing is to keep the ball moving forward and adding people as you go along and getting buy-in from the business, that the business recognizes this is a part of the onboarding process. And a natural partner for every trade compliance officer is procurement. The procurement office of or department of your company is your natural partner here, and they know about sanctions, and they are going to know that we have to do something about it. And I tend to work very closely on the procurement side.
Yeah. So you mentioned something really interesting, and it's always I don't want to say a point of contention, convincing the business. So when you're in a very large company with very mature, like supply chain or procurement or compliance functions, we're not having these conversations about sanctions as much. But maybe in smaller organizations, you might have a business owner really pushing to move quickly to get international vendor onboarded, right? Oh, we have some contracts we need to sign to get a discount or whatever pressures are built into that conversation. So, can you give practitioners a practical explainer for the business? How could they talk to the business very succinctly and effectively to
Yeah,
emphasize
I
the
think
importance of this step?
Yeah, I think there's a way to approach the business and to say, look, we are not here to obstruct. We want the business to succeed, and we want to get these people onboarded quickly. And at the same time, we want to protect you and protect you from scrutiny by the government, or we want to make sure that no bank of ours blocks a transaction. And so if you work with us at the onboarding phase, when you first identify a prospective vendor that you want to onboard, include us in the seat at the table there. Give us a seat at that table, and we will screen this and get back to you quickly. And we promise to be, and you do have to be mindful of the business needs here in that
Mm-hmm.
they want to move forward. You have to make them into a partner. The worst way anybody in compliance can walk into a room and everybody says, oh, damn, here's the sheriff. And that's not what you want to be. You want to be a business partner. And I want to say, look, if you bring it to me early, I will come up with I'm going to explore every way that we can do this deal. Okay. And I know
Mm-hmm.
the ins and outs of sanctions, and there are ways you can do things. Work with me. And I promise to be your partner and prompt. And we'll work on solutions. And they know, because imagine you're the business and all of a sudden the Treasury office calls and says, hey, why was this transaction stopped by Wells Fargo Bank? They're our bank. And you don't want to be justifying that to the head of
Exactly.
Treasury in your company. So you're there to watch their back and to make sure. But I want to be also a business partner. And I'll say, here's some language to include in the purchase order or the contract on compliance. Everybody knows this language and everybody signs it. So don't worry. These people should be okay. And also, look, we don't want to conduct business with designated entities.
Right.
They're usually on the list for a reason, which is they could be involved in drugs. They could be, Apple had a vendor that they used for years that was associated with a drug trafficking cartel. And imagine when that settlement and came out, Apple's dealing with traffickers. That's not like a really good piece of PR. So we're there to keep everybody out of trouble and make everybody look good. That's what we're doing.
Right.
But do
Right.
not come in like the sheriff and I'm going to put everybody in jail. Then you're going to be ignored right from the beginning.
Exactly. So I think that's really helpful. I do want to talk a little bit, go back to the tools a little bit. So, right from the beginning, we said get a tool, right, that has the
Correct.
capability to do this. It's probably one of the more foolproof ways that you can automate a lot of this information, including those alerts if something changes, but it also is very defensible during an audit or an exam or anything that says, yeah, well, we use one of these services to do this. What about smaller organizations that aren't ready to implement new technology or tools? Is there anything they can do to manage sanctions exposure? Is there a recommended like
Well,
minimum requirement that they can be managing?
well, okay. So here's the way, this is what we see. There are smaller companies who are getting into the international marketplace.
Hmm.
And for that reason, they don't want to spend, and it's not a lot of money for one of these automated tools limited to sanction screening or, looking at all the sanctions around the globe. But let's say they're getting their international business off right then and there, and for a few months before they want to see how they do, and is it going to justify spending money for an automated tool? Um, there's two things that people do. One, you can go to the OFAC site and they have a way to search whether a name of an individual or an entity. It's a OFAC sanction screening tool that's online, and you can put the name in there. I don't think you said the most important word, defensible.
Yeah.
Um, in other words, you can start that way. The other thing that people do, they'll use a law firm or a consultant like us and say, we want to use this person, and we'll clear them for them very quickly and say it's okay. And we don't charge, you can't charge much money for something like that. We're trying to help them to grow their business. That can also be as a temporary stopgap. We do that for some companies that are just getting into the international marketplace. Eventually, you're going to be successful enough in the international marketplace that you have to have, depending on how much revenue you're generating, an automated tool somewhere.
Mhm.
And they're not that expensive, and they're very good tools, and they do what you were just saying, Hilary, about the monitoring. They will monitor any name that's screened through there. They will then monitor it, and if it comes up again, they'll notify you. So that's, to me, there is that gap between nothing and automated tool. Then once you have an automated tool, people build on that. But that automated tool is going to be the central focus of your sanction screening program or your compliance program, around which you're going to do training, around which you're going to have controls for escalation of red flags so that somebody can double check me, if I run a screen, and make sure that there's a process to resolve red flags. Okay, to
Mm.
resolve red flags. So that's sort of the life cycle of a compliance program, where it starts in the beginning, where you get to in the middle, and then once your international business grows, if you have a significant, let's say 30% of your revenue comes from overseas sales, you probably should have a sanctions compliance program on paper and operationalized. It's a lot easier than an anti-corruption compliance program. There's a lot more discretion and other issues that get involved. Sanctions is a lot of yes or no, and that's it.
Okay. You bring up something that reminds me, when we talk about organizations of different sizes, my 25 years plus in third-party risk management has helped me understand not only our organization sized and resourced differently, but divisions like compliance may be under a separate, team. They may be in an adjacent part of it. You may not have control over it. The same goes for supply chain or procurement. So one of the things that I always recommend to any practitioner is, regardless of how your organization is structured, is to be aware of who makes those type of calls in your organization and be a partner with them. Because even if it's a situation where you have to send something off for a compliance check and they do it and they come back with a yes or no, and that's just your process, you still should know what goes into that. You still should know who's on point for making the decisions, the tools or technology they use, and make it part of the regular discussion, maybe once a year, to just, as you're going through your process, to be aware of what other functions are doing to support third party risk management if it's not sitting directly within your team. Um,
That that's a terrific point. And the range that I see, and you really made a great point. That one client company I had, they had in Salesforce a control that no customer or whatever could be onboarded unless on Salesforce there was a check from the compliance department that said this person is fine and been screened for sanctions compliance. Then
yeah,
then that person was made available. Now that's one way of doing it, and I kind of like that approach. But then I've seen in companies where you have a procurement operation, but you have a sustainability group that
yeah,
in a particular industry is managing and looking at your third party supply chain, and looking for conflict minerals, looking for human trafficking, looking for child labor, looking for
mhm,
all of these things. And frankly, it's not always clear whether you deal with procurement or sustainability in
yeah,
terms of bringing a new vendor on board. Oftentimes, they make it cumbersome and they have both involved. Well, like you're saying, we need to define a process and a control, a workflow that will then make this process work. I'm not saying somebody has to be in the lead on the supply chain side, and oftentimes it's procurement, but sustainability, depending on if you're in a clothing industry, Sustainability and not using child labor is huge
Yeah,
because of all the controversies that have occurred. So you've got to see who's going to be taking responsibility. Sustainability could be part of the equation, but they're not going to be the control that says yes or no. So,
correct.
and what you're saying is, the organization has to define a set of processes and workflows. And that often takes a lot of negotiation. Trust me. I've sat there for, 6 months trying to get procurement to add 4 questions to their onboarding questionnaire, which were relevant to sanctions. So
Yeah,
you, you've got to get cooperation and buy-in. And then that backs up to the big point, which is leadership has to communicate this message. We are going to manage our third-party risks. We are only going to contract with people who are consistent with our culture and our commitment to compliance. And we have a program that's been put in place. It's a simple communication, and we expect everybody to follow this.
yeah. I mean, I wanted to add to that, you know, third-party risk management looks different in every organization. In some, like you
Yes,
mentioned, we have those ESG or sustainability checks.
correct.
We have supply chain, we have procurement, we might have compliance sitting under legal. The bottom line is if you're in the third-party risk management space, whether it's combined, all of these risk domains and checks, or whether it's distributed, as a third party risk management practitioner, program manager, leader, you need to understand what those practices are. Even if it's only like you get a list that says, yes, it's been approved, you still need to know what they are and be able to explain them to your business lines, to auditors if they come in and ask you. It's important to know, even if you don't own that process. So I think that's a real
I
important
agree.
distinction here. Yeah,
I agree. And what you're talking about is the role of compliance is line of sight across the organization so that you know who's managing which risk and who you need to get control sign off from, but also that are other sources of information and risk management that you will enlist to help in your third party risk program. Interestingly, one other new player, I think, in this has been, I see them now in companies called risk managers. And now
mhm,
they're all of a sudden, okay, what's our biggest risk? Well, it turns out it's third parties, cybersecurity, AI, and third parties. And we're
yeah.
always this is ironic, but third party risk is always in the top three. Okay.
I always like to say that's because, people tend to look at risk as all the risks the company faces, and they tend to look down. What are we doing? What's our spend? What's our budget?
Right.
The thing that's unique about third party risk, which I think a lot of people don't really understand, is it's everything else. It's everything outside the walls, right? It's all of those vendor partner relationships, revenue shares, all of those things are in the third party bucket. And so it's much harder to contain, it's much harder to qualify. And that's why one, need to have a good scope. Two, you need to have clear processes and rules, and you need to have a good understanding of the business, what they're doing, right? So that
Right.
you know when something feels weird or wrong. And you also know who are the partners internally to help you manage it. So,
And
um,
and that's why I always say procurement is usually my best friend when we're,
exactly.
and in other words, you are nice to procurement. You bring them, flowers, whatever, you bring them, you acknowledge their birthdays, you do everything for them because they're your partner.
They certainly are very valuable and crucial partners in many, many organizations. So I want to
Yeah.
shift quickly because we've been talking about sanctions. Oh, you don't want to get caught with the sanctions. Something happened.
Right.
Let's jump to the scenario of I have a long-term supplier. They've been in my sanctions list. They've come through as fine, no problem. we're in the middle of a 5-year contract with them, and then all of a sudden a sanctions notice comes up. What
Right.
are the logical kind of first steps and actions that people should take or consider from a third party risk management perspective?
I would immediately, if that happens with a long-term relationship with a third party and they come up on a sanctions notice, you would immediately contact them and say, we have received this notice. Can you explain to us what is occurring or what has occurred? And usually they'll get back to you very quickly because you're not going to be able to clear any transaction with them at all. And I'm going to tell you how bad it can get. You can be in the middle of a transaction.
Hmm.
In other words, you've delivered the goods and now you're waiting to get paid, and boom, sanctions notice comes out. You cannot collect that money. You have to stop. And so you immediately go to those folks and say, what is going on? And ask for an explanation. Now, your protection is that in your contract or purchase order, we have standard OFAC or sanctions compliance language that allows us to discontinue operations, even give them a time period to cure. And we are going to be able to say, we cannot conduct this transaction because it's in violation of law. Your contract will protect you in that situation. And
Hmm.
most everybody, as part of a sanction screening program, we will include contractual provisions in our contracts or in our purchase orders, our forms. Everybody's used to that. But then you have to, and you may get an explanation, and you may have to then look at the explanation and see if it makes sense. And if it's defensible from your trade compliance perspective, then you may be able to resume business. But your first thing is to just stop all business and then investigate and
Okay.
promptly and promptly.
And would you recommend also, notifying your compliance, your COO, like who should we
Everybody,
also be talking to? Okay, because
your
certainly,
your business needs to know right away,
yeah,
and they have to be warned not to engage in any further business with them for fear of their own personal liability as well as the company.
yeah,
And so we that's sort of a stop order, and we have to be able to do it. It's like, I mean, honestly, it's like a safety issue comes up and you stop work. Here, it's the same thing because there's no, on the face of it, there's no, hey, you get 30 days to implement this. It's done. It's announced, and you need to immediately comply.
okay,
So that's the way you deal with it. Don't freak out because there may be an explanation for it, but this is where trade compliance people earn their money in that they immediately will investigate and then give you a quick read on, yes, you've got an issue.
okay, great. So we're coming to the end of our time, but before we get ready to go, can you give one or two sort of concrete actions that practitioners can take in this space, either something to consider, something to do?
Well, most importantly is what I talked about in our discussion about putting in some kind of automated screening tool. And they're not so expensive. The OFAC expects you to have one.
Hmm.
And they're clear in their guidance. They make it very clear that number one, you have an automated program. Second, a screening program. Second issue, mandated by OFAC, mandate requirement is that you conduct once a year OFAC sanctions training. Now, not for
Mm,
the entire organization,
sure.
but for those people who responsible persons who come up against this issue, you need to train them once a year. And that's usually a great process because it opens the door to communications where people will bring you all their questions and say, what about this? What about that? And you get more and more intel and info about what the business is doing that way. So
Those are,
my two main things are train, communicate, and get a tool.
I love it. Well, thank you. So, Michael, we are so happy you were here with us today. Before you go, we know that you are a pretty avid blogger and you have your own podcast. So, if folks want to hear more from you, where can they find you?
Well, first off, I have a lot of videos and webinars that I've recorded, including sanctions compliance on Volkov Law TV. It's on YouTube at Volkov Law TV, VOLKOV, LAW TV. Also, you can contact me on LinkedIn. I'm on that. And I maintain the blog Corruption, Crime, and Compliance, and we write a lot about trade compliance. And I have a podcast, which I'll probably have Hilary on at some point. We have to, reciprocate. And that's under the same name, Corruption, Crime, and Compliance. And we will talk about, I'll have a whole episode for 6 minutes, 8 minutes about an enforcement action and lessons learned for compliance. And also feel free to reach out anytime at my email, mvolkov, that's M as in Mary, Volkov, at Volkov Law, VOLKOVLAW.com. And I'm more than happy to answer questions. I don't run my business as, oh, to talk to me, I'm so important that you have to pay me money. I am passionate about compliance. I'm passionate about trade compliance. I find sanctions compliance a fascinating issue, and I'm here to help. So if you have questions, feel free to reach out. No requirements, no payments, no engagement letter. Down the road, if you need help, we can do that. But I'm here to help you so that you don't get into trouble in the beginning. And I want to thank Third Party Risk Association, because this is what you all are bringing to the table, which is you have great resources on your website that people should look at. There's terrific materials, templates, go-bys that are just phenomenal. And I have lots of stuff, and I always will share anything with anyone.
Well, we really appreciate the shout out. We're so happy you were here with us today. For the listeners, we hope that this conversation has given you a better sense of what sanctions are, what they mean to third party risk, and how to address them in your program. So we'd like to thank you for tuning in, and we'll catch you next time.
Do you have a third-party risk management question or topic idea for an upcoming episode? Send your questions to pod@tprassociation.org. The Third Party Risk Association is the only not-for-profit vendor and framework-agnostic professional association for third-party risk management professionals, bringing together thousands of practitioners and leaders worldwide. TPRA offers tools, templates, training, certifications, networking, and shared industry practices designed to support both your program and your professional development. Practitioner membership is free. To join, visit tprassociation.org and select Join under Membership.